full disclosure, doing commercials for Chris Salatino's campaign. But it is on hold currently, and on the line right now is Chris Salatino. Good morning, Chris.
Good morning, gentlemen. Good morning, Bill. How are you?
Wonderful. So we're going to get into the Manaski was able to get the, I believe from your attorney, the decision from the judge, which ruled to take you off off both lines, off two lines, based on what? I'm going to let Jeff kind of handle this because he's been digging into the decision. So let's start with Jeff. What happened here? What's going on?
Well, so I alluded to this a bit earlier this morning. Sometimes candidates get booted off. Oftentimes petitions are challenged. Ultimately, the decision was, as we know, we reported earlier this week, Mr. Salatino has been kicked off both the Working Families ballot and the Democratic Party ballot. So there will not be a primary, at least as it stands now. He said he intends to appeal. Chris, in reading this, I got to be honest with you. I'll say what I said earlier this morning. I was really surprised what the judge ruled here in this case. The word fraud is used several times. There's claims that you said you witnessed things and signed things, and in fact you didn't. It talks about appealing, but appealing would just be rebuttal of witnesses who testified whose testimony was different than yours. We want to be fair and give you a chance to answer this, but I thought it was a very damning ruling from the judge.
Actually, I didn't think it was.
Chris, can I just have you get off speaker because we have a difficult time on speaker. If you just pick up the phone, that'll help a lot.
Let's see if we can do that. Hold on one second.
Okay. Something about speakers. I don't know what it is. I like the big woofers from the 70s. These today just don't do the trick. All right. So go ahead, Chris.
Well, again, first of all, I wanted to speak to the commitment that we've made to the party, the community, and my supporters, and I'm moving forward with appeal. That we know, and to just, I guess, look at or answer his question. There's been no fraud on my part. Okay, and and there was nothing proved to that, and that's one of the things that we're looking at. Look, when you know what you do when you go out, people come in. They hand you signatures. They are supporters, and they say, hey, we're going to go out and we're going to do this, and we're going to get you some signatures. And you take them and you assume that they're going to be as accurate as could be, and unfortunately sometimes they're not. Does it rise to the level of removing a candidate from the ballot? I don't believe so. You know, the decision should be up to the voters, not the court.
But this, some of the allegations, you are correct. In some cases here, and I'm not going to get into names, okay, for instance, I believe there's a Mr. F who was collecting signatures on your behalf. He signed a document that said he saw all the people sign, and that's not necessarily the case based on what the court said. Now, that's someone else. But some of these involve you directly, that you signed documents when you did not see people, you did not witness people sign, and you said that you did. And then there's one part in here where the judge says, in his ruling, you made a statement to the court. Someone else came in, gave a different side, and then you changed your testimony.
That's no one else came in, and that's not accurate. Okay, and that's one of the things that we'll discuss in the appeal itself.
Are you saying that what the judge put in his decision is not accurate? We
feel he's erred in his decision and his interpretation of the law. Okay. And I'm not going to speak to a lot of this, and unfortunately, we are still in litigation. So there's a lot of things that I can discuss, and there's some things that I can't.
I do want to go back myself. I do want to go back to the part about because this is big. If he put in his decision that there was not a witness, if there was a witness that didn't exist, this sounds like this is something that's slanted against you, Chris.
Well, again, there was no witness that came in and said, hey, and again, I can't speak to a lot of this because of the appeal, but there was never a witness that said, hey, we didn't want to support Chris. Every person that came in said, hey, we're here, we signed for Chris. And that's really the intention and really the driving force behind petitions. You know, did they want to sign for you? Did they want to? And did they support you? And that's absolutely the case in each and every one of these. I mean, the only criteria to run an election law is sufficient number of signatures, and we still have sufficient number of signatures. So, it's typically, if there's a question on a petition, you remove that individual from the line. You don't remove the candidate from the ballot.
But
and I think we're approaching the decision is. I think we're approaching new law here, and I think the appellate division will have an interesting review.
I want to go back to that witness though. So what did the witness say? There was a witness.
There were a lot of witnesses, and I don't know particularly which one he's referring to or what they're referring to. But like I said, we're heading to the appellate division, and we're still in litigation.
And did testimony? Why does he say did testimony change? Did your testimony change? And you're saying that didn't happen.
I don't believe so, and that's one of the things. And if it was, there might be some ambiguity in there. But we didn't change testimony. You know what? And again, at the end of the day, our goal here was to make sure we had a sufficient number of signatures, and we've had sufficient number of signatures.
I'll give it back to Manaski here.
All right. So you're absolutely right. I don't see anything in this paperwork. To that point, you are correct. Nobody's saying they signed my name, and I actually don't support Chris Salatino. I don't see anything reflected in what I have in front of me. So I agree with you on that point.
Nor does it say that Chris Salatino committed fraud.
I'm sorry, Chris. It does say that. I'm sorry. I'm not saying that. That is what the paperwork says. This is from the judge. It says it. I can read it to you right here. It says right here, Mr. Salatino has testified he was standing behind. I've got a lot of stuff highlighted here. A candidate who falsely signs witness statements constitutes fraud and requires the invalidation of the entire designating petition. The judge determined, based on testimony from multiple parties, that you falsely signed witness statements, and the judge says that constitutes fraud.
No, and that's not accurate. And like I said, we're in the middle of litigation, and I'm not going to speak to that because of the pending litigation. But I will tell you this, that there was no fraud committed on our part. On my part.
You have to.
Period.
If you did not do this, you have to clear this up, because if I'm understanding this correctly, based on what I've read from the State Board of Elections and these petitions, what the judge ruled you did amounts to perjury, unless I'm misreading this.
And I believe you are. And I believe the decision didn't say that, and it didn't directly. Remember,
I'm
we have
reading right here
that are accurate, and witnesses that say that it didn't. And again, we're going to move forward with the appeal. And, we have we certainly currently have the sufficient number of signatures on the ballot. So we have enough to continue in moving forward, and we're going to allow again, if there's, and you read a portion of the election law that said if there's an issue with a signature or a designated petitioner, then they remove those particular items or those petitions, period.
And that's,
you don't remove the calendar. And that's really the driving force behind petitions. Nobody intends to go out and give me a set of petitions and say, hey, we didn't, they weren't accurate. We accept them as face value, and we hope that would continue.
I guess ultimately the court will make a decision on this. I think he does make a fair point in that normally a signature is removed. But I'm reading that it was different in this case because you were the one who the court determined signed the documents as a witness, and when you were not there. And I think that's part of the reason. Again, and I'll read it again.
And again, we're in litigation, but I was there. And that's and we're talking one signature that I believe was a question, but I was there and I did witness the signature.
What testimony?
And that's it.
Yeah. What testimony do you have any idea when he says that you changed testimony, you gave one answer, and then after a witness you gave another? Do you have any idea what he's talking about there? And you think
I don't believe so at this point, and I think that's something that we need to when we read the court transcripts, we'll move forward. But like I said, we feel that when we move forward with the appeal, that he erred in his decision, and we're going to move forward with the appeal.
Manaski.
To be more clear, and you can comment on this or not, and I won't use the individuals' names. This involved a husband and wife, both who said they would sign for you, but part of this says you cannot sign for anyone else. So, for instance, Bill, you and your wife are supporting a candidate. She's not home. She's at school. You cannot sign her name. Okay, so what? If I'm reading this correctly, what it says is a husband and wife signed because of a medical condition, and it says it right here in the paperwork, had asked his wife to sign for him because of a physical issue, and he had trouble signing his name. So the wife signed the name for him based on these documents, after they came in and clarified the situation, Mr. Salatino it says here, changed his testimony because he said nobody signed for anybody else. And obviously that's a case where you have a wife signing for a husband.
Oh, so
that was the part of the testimony that changed, according to the court documents.
Do you remember that part, Chris?
What's that?
You remember that part?
I'm sorry. That part of I broke up for just a moment, but I believe he's talking about someone that had a physical ailment.
Correct.
Whose wife had the authority to sign for her husband.
Correct.
And that's the issue. And she had the authority to do that.
So how is that something that is illegal? I don't understand.
Well, it says you can't sign for anyone else.
If someone turns to someone and say, "Hey, I can't physically sign this, but you have the authority to sign something for your husband or your wife," and they do that, does that constitute fraud in his presence? I don't believe so.
Yeah.
So if there's an issue with that, and there was an error with that particular one, then you throw it out.
Right.
Does that constitute removing the opportunity of democracy for the people of this community to decide who they want for their particular office? I don't believe so.
Yeah.
And that doesn't rise to that event. And that's why we feel that we have a strong appeal, and we're going to hope that they make the right decision as well.
And just to be clear, that's the area where the judge says Chris changed his testimony.
That's the area where I read the only point in this ruling where I see he says he's changed his testimony. But there are additional allegations.
So we have a husband that's
Correct.
incapable and unable to sign his name because of a medical and physical ailment. Mm-hmm. The wife signs it, and that constitutes fraud. I hardly think that's the case.
I think that's a fair point you bring up, but that's not what constitutes fraud. What constitutes fraud, what the judge ruled, is that you saying nobody did that and testifying to that is what constitutes fraud.
And again, in someone's presence, and did we see it or did we know it? Remember, we're out there seeing thousands of people, and recollections and things are difficult. But at the end of the day, no.
In fairness, this is one of the lesser.
We are going to move forward with the appeal, and I believe that, and we have the sufficient enough number of signatures at this point to continue on to the ballot pending the appeal.
All right, and Jeff,
again,
that was. I got to tell you, and I have great deference for the process and the judicial system, but I disagree with the decision.
Right.
I believe the judge erred in his interpretation of the law and in his decision.
Chris, you carried petitions before when on the school board. Is there a petition process that's similar to a political election?
Not necessarily. The school board election is bipartisan. It's not bipartisan. So either Republicans or Democrats, and you just need a sufficient number of signatures to sign.
All right. So I
want to remind everyone that we had a hearing in Albany with the State Board of Elections, and they cleared the challenge. Okay, and they are the people that typically review these things. They review them. The arguments are made on both sides. They look at some signatures. Some will get removed. Some of them will, they'll stay. And we were cleared by them.
They did take away some signatures, but they validated much more than the 500 that he needed. I believe the opponent campaign, or the petitioner in this case, further challenged them, and that's why it went to court. But if you're saying that's not true, you got to get, because Chris, if I'm reading this correct, what you did, and the judge uses the word fraud again. I just was on the Board of Elections website. I believe you can be charged with perjury. You need to clear your name on that if that's not what happened.
We you know what, we're moving forward. There is no perjury. There was no fraud, and or anything that even approaches the Constitution of that type of verbiage or word or any of that. Anything. So, again, we're moving forward. We know we have enough, the sufficient number of signatures. We are moving forward with the Court of Appeals, and we'll wait their decision.
I want to ask you, can you talk about the Court of Appeals? That'll be the appellate division. And when that happens, because obviously you're on the primary is September 13th. And personally, I'd like to get this thing wrapped up for my own reasons. But
you don't have much time. What's your?
The time is ticking. So what's the timeline here?
I don't know at this point. We're waiting the attorneys to get back, get a date for the Court of Appeals, and move forward with the appeal.
All right.
And we're going to continue to move forward. We're going to continue to campaign, and we're going to continue to fight this thing.
Okay.
Because at the end of the day, the decision should be up to the voters and not the court.
But there are procedures.
And we have sufficient number of signatures to stay on the ballot. Typically, and even looking at previous case law, you will remove any signatures that may be contrary, that may have had some issues, that may have not been. Maybe someone switched parties, or maybe
wouldn't they normally just throw out that petition? So that petition would be either they remove the signatures from that petition, or that petition would just get thrown out.
would get thrown out.
Right. But in this case,
that's typically.
And would you still have enough signatures if that were the case? You'd still have enough?
He says it in there. We have enough right now.
Okay. In the Democratic primary, he would still have enough. But again, I believe it's different in this case because the violation is on the candidate. For instance, the Brian Miller case, okay, there were a lot of differences in the two cases, but the violation occurred by a staffer, not the candidate, and I think that's why all of the petitions were thrown out.
Andrew, somebody's asking.
That's inaccurate, and again, as far as I'm concerned, and with the judge's decision, we believe he erred in his decision.
All right.
Chris, I have somebody texting in a question: if the school board attorney has been paid by you, if you
what does that have to do with?
It has nothing to do with who we pay and what we pay and anything else with the school board attorney.
Why are they asking about the school? Why would they ask about the school board attorney?
Because it's Don Gerace and he's also my attorney as well.
Okay. So what is the question?
They just ask if you paid the school board attorney
Of course.
on this case.
Yeah.
Well, the attorney can work for free if he wants to.
Yeah.
Chris is not under an obligation to pay him if the guy doesn't want to get paid.
Let's face it. We have to pay everyone, gentlemen.
Yeah, no, I know. But the whole idea that...
Is someone implying, though, that you're not paying for the school board attorney? Or you're not paying
I don't know, and that doesn't really have any relevance right now what we're speaking with. What we're trying to do here is discuss the inaccuracies that were stated, and also the
I guess the question
process as we move forward.
I guess the question would be: is the school board? Is your attorney working pro bono on this case? Is your attorney working pro
Absolutely
bono?
Not.
So he's being paid. Yeah, that's a ridiculous question. Then.
Yeah, I agree.
I
don't know many people that work for free. I can tell you that.
I agree with that. So, all right, Chris. I think you've been through a lot here. Holy moly!
Well, and I appreciate you coming on to answer this, Chris. Let me say this. Let me just say this. I appreciate you coming on to answer this because these are really strong allegations, and I appreciate you having the courage to come on and face the questions.
We take things at face value. Typically, if there's an issue, if there's a concern, you remove those particular signatures. And I think that's where the election law comes in and says, hey, those are issues. And there's issues with any type of candidate, any type of, again, we rely on people to go out there and get signatures, and you hope the accuracy is there.
And on the
people
appellate,
provide those to you.
On the appellate court, normally it takes quite a while to get before the appellate court. I'm assuming because there's a pending primary going on here, the importance of this is to get you in quickly.
And that's what the goal is, and I believe we can. I believe our attorneys are working on that right now to make sure that we get a court case, we get it in, and we get before them as quick as possible. There's documentation that needs to be done. There's legal briefs that need to be done. So they're working on all of that right now, and it's a quick and swift moving process. Yeah. We would hope, especially in this case. But like I said, you know what? The judicial process is what it is. I have deference for the system. I disagree with the decision. And I think that at the end of the day, the judge's decision is, approaching new law, and the appellate division will have an interesting review.
Right.
As far as to remove a candidate and not allow the democracy to work, I think is not a good thing. People and voters, and I have to tell you, my support has been overwhelming. It's been absolutely overwhelming.
Chris Salatino, I appreciate you. You didn't have to. I appreciate you coming on and clearing things up here for everybody. And we'll be following this process. Hopefully, a swift process, making it to the appellate court.
Great. I look forward to it, and I look forward to getting through the process.
Yeah.
And I appreciate the opportunity to come on and speak to you, gentlemen. And we'll let you know how things work out. But we are going to continue to move forward. We're going to continue to campaign, and we are going to continue to work with our supporters. And for those who have been so overwhelmingly supportive for me, I thank them.
Chris Salatino, thanks so much. We'll do it again. Thank you. All right, we'll break.